And the Central Coast Saxon Mullins lost her virginity at 18 on her hands and knees in the gravel behind a nightclub in King's Cross. Not the way she imagined it. It was an awful story. She called it rape, but the young man involved, the son of the nightclub owner, insisted it was a terrible misunderstanding, which he bitterly regretted. A 5-year criminal legal battle ended with no finality for anyone. A jury and a series of judges found Saxon did not consent to sex, but the legal sticking point was whether the accused knew she was not consenting. This week, the New South Wales government announced changes to the laws. The new model could see defendants convicted unless they have taken active steps to obtain consent for sex. Here's what Saxon Mullins told us on the ABC earlier this week after the announcement. And then we'll hear from local legal expert Manny Conditsis, and he's a top legal representative in these sorts of cases too, in criminal law. Joins us to talk about the new legislation and how it will work in the real world of the courts. Here's what Saxon Mullins had to say.
I'm in a bit of shock, but I'm just really relieved that the Attorney General has listened to survivors and to experts and made sure this law has come about. When the Law Reform Commission came out with their final report that didn't recommend affirmative consent, we thought this hurdle is just too high for us now. Why would they go further? But thankfully, reason came about and we were listened to and experts were listened to, and affirmative consent is where we've landed. So it's a great place to be. The court experience is always awful, but the fact that, there were 2 trials, 2 appeals, and ultimately, even though our appeal was upheld, it just apparently wasn't worth it to go further. I'm glad that we're hopefully, ending cases like that and ending that sort of legal limbo that I was in for so many years. So I'm glad that we're actually, looking into the realities of sexual violence. I mean, we've basically, before we changed this law, we basically were just ignoring the fact that a lot, and very well documented, a lot of sexual violence survivors freeze. It's a very normal response. And we were just totally ignoring that with how the law was legislated. So I'm really, really glad that we've seemed to have fixed it.
Central Coast woman Saxon Mullins there. This from the Attorney General, Mark Speakman.
The Law Reform Commission suggested that there should be no consent unless it has been communicated by an act or a word, and we've accepted that recommendation. We've gone a bit further in relation to the state of mind in relation to the accused. So for someone to be guilty of sexual assault at the moment, they either have to have known there was no consent, be reckless, or have no reasonable grounds for belief. In relation to a reasonable belief, we're going further than the Law Reform Commission by requiring the accused to have done something or said something to ascertain consent to form that reasonable belief. And this is because the view is that this is all about respect for sexual partners and having respectful consensual encounters and making sure through communication that a sexual encounter is wanted. Not assuming it from lack of protest or lack of physical resistance, but just asking a simple question or getting a simple gesture that indicates that the partner wants a sexual encounter. I've tried to approach this methodically and systematically. The Law Reform Commission received thousands of public comments, hundreds of stakeholder submissions. We've digested all that, and I hope we've landed in a pretty good place.
And Central Coast lawyer Manny Conditsis also passed on submissions through his peak body, the Law Society. I think it is. Manny, good morning.
Good morning, Scott. Good to be with you.
Yeah. So people in your situation who have to on almost a daily basis deal with these laws, hopefully had a good say. What was your submission, and how does the legislation differ from what the lawyers were recommending?
Well, essentially, there was a lot of dialogue over a period of more than 2 years with the Law Reform Commission, and a very serious consideration was given, as the attorney said, by all the stakeholders and the Law Reform Commission. I think it's very important to pause and consider some things. Firstly, the Attorney again is quite right to say that the New South Wales Law Reform Commission did not make ultimately the recommendation for Parliament to adopt the affirmative consent model in relation to any change of the law.
Just before we get into whether it's workable in court or whether people could be wrongly accused, the legislation itself, what does that affirmative consent mean?
Well, let's take a step back. The law that was in place at the time that Mr. Lazarus was charged in relation to the sexual assault of Saxon Mullins was this, and the Attorney mentioned it, but let me just break it down a little bit. The law was then that to be found guilty of a rape, of a sexual assault, the prosecution had to prove beyond a reasonable doubt that the complainant was not consenting to the particular act. One would think, well, that's perfectly reasonable. The prosecution also had to prove or negate the possibility that the accused had a belief that the sex was being consented to. The way that it would do that would be to have clear evidence that, for example, the complainant said no or did some act that made it clear that, or ought to have made it clear, that she was not consenting. So in that circumstance where you have a clear example, it's pretty clear-cut and the legislation did its job. However, the prosecution had to prove that the knowledge or the expressed belief of the accused that he was not consenting was not reasonable. A way that could have been done would be to establish that the accused was being reckless, wasn't really caring whether the complainant was consenting or not. And as the Attorney said, as the legislation was, any belief by the accused that the complainant was consenting had to be based on reasonable grounds. Now, a lot of legal commentators would look at the law as it was, or indeed as it is right at this moment until this legislation comes to be, would say, well, why doesn't that capture a circumstance where a complainant has frozen? So that's the law as it was. The affirmative consent model makes this essential change, that unless the accused can point to something that he said or did with a view to obtaining the consent of the complainant, then any expressed belief he has that she consented will not be based on reasonable grounds and will fail. So that's the affirmative consent model. The accused will have to point to something he did or said to be for his belief that she was consenting to be accepted in court.
We must say too, when you do programs like Consent Matters at the University of Newcastle, you can't study there before you finish that compulsory program. They do also make the distinction of same-sex couples. It's not just a man and a woman. There are lots of different scenarios, aren't there?
Of course, and I'm just trying to keep it simple for the purpose of this interview.
Quite
talk
understandable.
About a man and a woman, but it doesn't equally. Of course, you're quite right, Scott. It applies to same-sex relationships and or others. But well,
there were 44 recommendations plus 2 extra from the government. Are they the ones that are a bit of a sticking point? How do you see this working in the court system? Because it's very important to get this right, isn't it?
Well, it's critical, and no one would argue that there should not be a proper balance. Everyone would agree that and again using the male-female analogy, that a female who says, I was sexually assaulted, I did not consent to this, then the person that offended should be brought before the courts and dealt with. No doubt whatsoever. However, it's very, very important to get the balance correct, because what we also don't, whilst on the one hand, yes, of course we want to protect and support and do everything we can in relation to complainants who say they've been sexually assaulted or who have been sexually assaulted. Equally, we need to be careful to ensure that we don't introduce laws that can capture an innocent circumstance, perhaps unintended. And I can give you some examples for consideration in that regard. For example, and let me also say this, until the actual detail of the legislation comes out, we are speculating a little bit as to how it will all play out. And so having regard to the release from the Attorney-General, to what the Attorney-General has said and what I understand is likely to come, I put forward a couple of hypotheticals. Firstly, it would seem that this legislation will also apply to what's called sexual touching. So we're not talking about just sexual intercourse. We're not talking about just rape as such. We are also talking about matters where someone might be touched on the bottom or on the breast or something.
Without consent, allegedly.
Without consent, correct.
Is this retrospective? Would this be retrospective?
No, there's been no indication to be retrospective, and that would be outrageous, really. It will. There's no indication it would be retrospective, and I don't imagine for a moment it would be. But if we look at a couple of examples, we have to remember that this legislation applies to people that have been in a relationship for 6 months, 6 years, 60 years, or they've just met at a nightclub dance floor. Right? So if you just pause and consider those circumstances, to try to apply a law such as affirmative consent across all those variables in relationships can be, depending on the circumstances when a complaint is made, quite problematic. Let me give you a couple of examples. In relation to sexual touching, assuming the affirmative consent model applies to sexual touching, and as I understand it, it will, a couple may have been in a relationship for whether it's days, weeks, months, and they're walking down the street and again, just to stay with a simple analogy, the male walking down the street, they're hand in hand, and he's walking down the street and he puts his hand on the bottom of the female. And that has happened on numerous occasions. And not at any time in that scenario did the female say, well, don't do that, I don't like that. Equally, nor did the male say, put his hand on the bottom as they're walking down the street, can I do this? So there appeared to have been some understanding on his part, but he didn't actually ask. Now, in 3 weeks, 1 month, 2 months' time, if he, in that analogy, did the same thing, and the woman made a complaint, then he could be found guilty based on this affirmative model introduced by Parliament of the offence of sexual touching. Now, some might say, well, he should have asked, but bear in mind the scenario I've set out. This has happened on a number of times. They're still in a relationship, still want to see each other, still go out together, and it's a fairly minimal type of touching on the outside as they're walking down hand in hand, and to any observer, the woman was consenting to it. The scenario of a, quote, freeze, close quote, wouldn't apply in that instance, I would have thought. However, applying affirmative consent model, if the woman made a complaint, he could be found guilty, and his expression of belief of consent would be to no avail. That's on a minor level. I can give you another example. That's
quite different, isn't it, to more serious cases with only 3% of sexual assault complaints ending up in conviction. You've got to think that the balance has been a bit skewed the other way.
Sure. Perhaps it has. And therefore, we have to get the balance right. In all laws that we pass, we in all laws in relation to sex matters or any other matter for that, for what it's worth. So the balance has to be right. The point is, will this tip the balance too far the other way? And a lot of legal commentators think that it will. Can I give you another example? Because that was a minor example. Let's look at a more serious situation where you might have a partner, two people, a couple who are participating in a particular sexual act, and there's no issue about that. It's consensual, right? And let's assume that in relation to the initial sexual act, and it could sexual intercourse of some kind, and again in the simple analogy of a male and a female, the woman has consented, and there may have even been discussion about it, and yes, we'll do this act, and it occurs. During that sexual act, another sexual act occurs. Might be.
Yeah, we won't go too deep into that.
Another sexual act occurs.
Yeah.
Now, and this, bearing in mind again, could be in a scenario where the couple have been together for 6 months, 6 years, or many years, or they've just met in a nightclub. Now, if you separate the scenarios, you say, look, they've just met on the nightclub, they only met an hour ago, then now it's in someone's apartment or in a car or wherever they are, then perhaps if there's a change from one sexual act to another, that person should ask, is this okay? No difficulty with that. But what about a scenario where the moving from one sexual act to another has occurred on multiple occasions previously in this particular relationship, whether it's been months or years? The precise same things happens on this occasion, and the woman might say, the complainant might say, well, hang on, I didn't consent. What did you do? And unless the accused lawyers or the accused can point to something he said or did, not what she did, that he said or did, then his belief won't be accepted as reasonable.
Manny Conditsis, look, it'll play out in the courts, I guess, and we'll see how this new legislation runs. Obviously, you perceive some problems. We'll see what happens. Look, thank you so much for joining us. Appreciate your perspective.